It was a night of 18th May 2024. A 24-year-old man Anish and 24-year-old woman Ashwini went to a club in Pune to party with their friends. Although they were originally from Jabalpur, Madhya Pradesh, they were both working in an IT company in Pune. The club they went to is called Baller, and about 3 kilometers away from this place, Vedant and his 12 friends meet at a pub called Kosi on the same night. The time was 10:40 p.m. when Vedant and his friend entered this pub, and within just hour and a half they spent lavishly, running up a food and drink bill of 48,000 rupees. The CCTV recordings of this time is publicly available, in which you can see Vedant and his friends drinking alcohol. It is important to note that Vedant is under 18-year-old, significantly below the minimum drinking age limit. Around 12 am, the pubs stop serving Vedant and his friends, so they leave the pub and heads to a club called Black, located a few kilometers away at the Marriott Suites. This place was also 3 kilometers away from the club where Anish and Ashwini were partying with their friends. Around 2 am, Vedant and two of his friends leave the Black Club and, in a drunken state, get into his electrical Porsche Taycan. Their household driver was also present in the car. At around 2:30 am, Anish and Ashwini were also returning home together on a motorcycle. Their motorcycle took a U-turn on Kalyani Nagar Airport Road when, on the same road, Vedant's Porsche flies by like a bullet fired from a pistol. This led to a terrible accident, and in few moments Anish and Ashwini pass away. According to some reports, the speed of the car was 160 kilometers per hour, while some other reports claim that it was going faster than 200 kilometers per hour. In the CCTV footage, you can see that the size of the road and how small it is. After the collision, the car's airbag deploy and the people standing nearby rush to the collision spot. After some pushing and shoving and questioning by the crowd, Vedant was handed over to the police by the people present there. They were convinced that the driver responsible for running over two individuals would face the most severe punishment. However, these individuals were unaware of the unexpected turns of events that would unfold later in this case. Vedant Agarwal was escorted to Yerwada police station. Merely an hour after the incident, MLA Sunil Tingre arrived at the police station at 3 am. Consider this, an MLA interrupted his sleep and made his way to the police station in a wee hour for a young man. Would any MLA undertake such action for just any random individual? The answer is no. As it turns out, Vedant Agarwal hails from a wealthy family background. His father, Vishal Agarwal, is a renowned builder and owner of the real estate company Brahma Corps. Sunil Tingre, an MLA affiliated with Ajit Pawar's NCP, which is currently allied with the BJP, made an appearance at the police station. In a subsequent interview with the News Laundry, Tingre clarified that he did not exert any influence on the case. He stated that his visit that night was due to his long-standing acquaintance with the Agarwal family spanning over 30 years. Considering them as friends, Tingre felt compelled to assist them upon their call for help. The following afternoon at the Yerwada police station, an intriguing incident unfolded. A Mercedes car accompanied by several others arrived, and a man emerged from Mercedes car carrying 6 to 7 pizza cartons. Reporters stationed outside the police station noted what seemed to resemble a feast occurring within its confines, pizza being served inside. Sunil Tingre departed from the police station around 6 am. Several hours later, at 8:26 am on 19th May 2024, an FIR was lodged against Vedant. The controversy surrounding the FIR stemmed from the section under which it was registered. It was filed under Section 30A rather than Section 304. There are significant distinctions between the two sections. Section 304A pertains to death by negligence, indicating that someone died due to a mistake made by another individual. This section carries a maximum penalty of 2 years in jail. On the contrary, Section 304 deals with culpable homicide not amounting to murder. Culpable homicide implies that the individual knew that their actions could result in someone's death, yet they proceeded despite this awareness. However, it falls short of meeting the criteria for murder, as murder necessitates a direct intention to kill someone. The critical distinction lies in whether you were aware of the potential consequences of your actions. Under Section 304, the maximum punishment is 10 years imprisonment precisely because it addresses situation where the individual knew or should have known that their mistake could result in someone's death. This awareness differentiates Section 304 from Section 304A. The question becomes, were you aware of the fact that someone could die as a result of your mistake? Now, let me ask you, in today's day and age, is there anyone who isn't aware that drunk driving can cause accidents and lead to fatalities? Is there anyone who doesn't understand that driving car at the speed of 200 kilometers per hour on a narrow city road can result in loss of life? Hence, the pertinent question arises, why was the FIR filed under the Section 304A and not 304? Was MLA Sunil Tingre influential in this recommendation? This is a crucial inquiry. Additionally, the issue regarding the car is separate. The permanent registration of the Porsche Taycan had been pending since March because Mr. Agarwal had not paid the fee of 1,758 rupees. Consequently, at the time of the accident, the car did not have a number plate. Vedant's grandfather disclosed that the car was gift for Vedant. Returning to the FIR, the police had to conduct a blood test on Vedant. It's noteworthy that this blood test was conducted at 11 in the morning, approximately 8 hours after the incident. Typically, alcohol remains detectable in the bloodstream for 6 to 12 hours depending on the amount consumed. Given the timing of the blood test, one might expect a positive result. However, surprisingly, the blood test came back negative, and the reason behind this outcome points to another deception. At the hospital where the blood test was conducted, the doctor who administered it allegedly disposed of the genuine blood sample and substituted it with another clean sample. This implies that the sample tested had already been tampered with. The Agarwal family reportedly paid 3 lakhs rupees to two doctors, Dr. Ajay Tavre and Dr. Srihari Alnur, for this fraudulent blood test. Both doctors have been since arrested. However, the saga of deceit and corruption doesn't end there. Vedant's mother purportedly urged their driver to take the blame for the accident. Furthermore, Vedant's grandfather went to an extreme length by threatening the driver and coercing him to confess that he was the one driving that night. Fortunately, there were numerous witnesses present that night thwarting any such attempt at deception. The most shocking development in this case occurred when Juvenile Justice Board granted bail to Vedant. As a condition of his bail, Vedant was required to study all relevant rules and regulations, prepare a presentation, and write a 300 words essay on a topic of road accident and their solutions. Despite the fact that Vedant's drunk driving resulted in deaths of 2 individuals, the punishment of writing a mere 300 words essay sparked widespread outrage across the country when news broke. Social media platforms were flooded with expression of indignation from the people across the nation. Amid widespread public outrage, the police took action by approaching the section court on 20th May 2024. Their aim was to have Vedant tried as adult and to amend the charge from section 304A to section 304. However, the section court directed the police to seek approval from the Juvenile Justice Board for this request. Additionally, the police decided to expand the scope of this case by booking more individuals. This included the owner of the club Kosi, his father and the manager, as well as the manager of the Black restaurant. During a court appearance of the remand application involving these individuals, Judge S.P. Pongshe made a noteworthy statement. He questioned the potential consequences for the public, highlighting the patrons leaving the large pub are unlikely to walk home but rather drive vehicles. He emphasizes the responsibility of alcohol servers to monitor the quantity served to the customer and proposed establishing limits accordingly. Did you understand this logic? The judge claims that the people who go to the pubs will inevitably drink and drive, suggesting that the pub owners should monitor the alcohol intake of each patron. In my opinion, this was a strange statement and seemed like an attempt to shift the blame from Vedant and his family to the pub owners. The only wrongdoing by the pub owners was serving alcohol to an underage boy. For this, either Vedant used a fake ID card or they served him without checking any ID. The investigation will reveal the extent of their culpability. Due to this mounting pressure on the police, an FIR was lodged against Vedant's father, Vishal Agarwal, under several charges. This include the section 75 for willful neglect of a child or exposing a child to a mental and physical harm, and section 75 for supplying a child with intoxicating liquor or drugs. Additionally, section of Motor Vehicles Act was cited, section 3, section 5 and section 199A for allowing Vedant to drive without a license. On 20th May 2024, the story took another twist with news of Vishal Agarwal being on the run. After securing bail for his son, he attempted to evade the authorities by purchasing a new SIM card to prevent tracking. However, his escape was short-lived. On 21st May 2024, he was arrested in Aurangabad. By this time, public outrage over this case had reached to its peak. Public outrage was immense, with every political leaders discussing the case. On 22nd May 2024, Vedant was brought before the juvenile court and an additional charge, section 185, for driving under the influence of alcohol was invoked. The police requested that Vedant be tried as an adult rather than as minor. It remains to be seen whether the court will grant this request. In the meantime, Vedant has been remanded to Nehru Udyog Kendra Observation Home. Here comes an interesting legal technicality that complicates the imposition of a strict action for Vedant. Under the law, criminal under 18 years of age often receive minimal punishment. This is due to a legal concept known as doli in capex, which pertains to the age of criminal responsibility. The principle holds that the children below a certain age cannot intentionally commit crimes of their own will. Therefore, the punishment for offenses committed by these children is not equivalent to that of adults. Instead of facing harsh penalties, these young offenders are given opportunities to reform. Research indicates that children who grew up in adverse environments and lack proper parenting are more likely to engage in criminal behavior. Through counseling and proper education, these children are given chance to reform. However, what about boys like Vedant? Vedant grew up in a wealthy family, enjoying every privilege, including a good education, a supportive family, and even a Porsche car at the age of 17. This raises the questions about the application of the principle of doli in capex in cases where the offenders has had all the advantages of a privileged upbringing. That is why I believe that Vedant should not be treated as minor. What are your thoughts on this? Please share your opinion in the comment section. The Pune case exposes the deep-rooted corruption within our country's system, revealing how the wealthy often bypasses the law. For the rich, everything seems permissible. With enough money, one can drive without a license, consume alcohol underage, and even speed at 200 kilometers per hour. When crimes are committed, influential figures like MLAs step in to offer assistance. Bribes can lead to doctor altering blood samples, and court may dole out minimal punishments such as writing an essay allowing everything to be forgiven. There is only one force that can bridge the gap between justice and injustice, and that is our unity, the collective voice of people. Money cannot buy this unity. In Vedant's case, the authorities are attempting to take strict action, and any hope of justice existed only because people have voiced their concern on social media. This situation serves as a lesson for all of us. We must always raise our voices against injustice. So thank you for watching the video. Your support means the world to me, and I look forward to bringing you more compelling stories and discussion in future. Until next time, take care and stay curious.